Good afternoon, ladies and gentlemen. We're just waiting for a few more online participants to join us for our CELS lunchtime seminar. It's my distinct pleasure to welcome Professor Antonio de Estella de Noriega from the University of Carlos III in Madrid. Antonio has been a visitor in the CELS, in the Center for European Legal Studies, for the past couple of months, and has been a friend of the University of Cambridge for many years. He's professor of administrative law and a Jean Monnet Professor ad personam of European economic governance law in his university in Madrid. Before that, he was a Jean Monnet Professor of European Union law between 2006 and 2010. He completed his PhD at the European University Institute and a master's degree in community law in Brussels after his legal studies at the Autonomous in Madrid. His career has been extremely distinguished, and that's why it's fantastic to hear him. He is widely published in administrative, constitutional, European theory and law, as well as, in particular, legal aspects of European economic governance. He's been a visiting professor in many universities, including in Oxford and Princeton, and his latest book with Cambridge University Press on the legal foundations of EU economic governance is truly trailblazing. I've used it numerous times in my teaching, so it's a personal pleasure to welcome Professor Estella for his lecture today. In Courts We Trust, Some Evidence for Law as Credibility. Antonio, bienvenidos.
Okay, thank you very much, Marcus, for this kind presentation that is surely due more to friendship than to my to my merits. It's a real pleasure to be here today in this distinguished institution, the Center for European Legal Studies, that has been so kind with me during all this year, this academic year, despite the pandemic situation that we have undergone. It's been a real pleasure to have been here in Cambridge for all this time, and of course here at the Center for European Legal Studies, which is a crucial institutional actor in the field of European Union law and European studies in general terms in the world. So thank you very much for treating me so well during all these months. Okay, we're going to speak today, I'm going to speak today about courts, trust and credibility. So the starting point of my talk is what I call the trust in political actors structure. So in this structure, what we have is that P, the principal, delegates power to A, the agent, and this is denoted by that formula over there. And from the moment in which P delegates power to A, P starts mistrusting A. So P, the principal, starts having problems of trust with the agent. So this is denoted by that formula there, P minus TA, where P is the principal, A the agent, and minus T denotes lack of trust in the agent. So there are many, many ways to illustrate and give some flesh to the previous structure. We could, for example, discuss it in theoretical terms. So, for example, the starting point of all this literature is a very well-known article by Schelling, that he published in 1982 on precisely credibility and the problems posed by credibility from very different angles. As we know, Thomas Schelling is an economist, Nobel Prize laureate, and he didn't deal specifically with the problems, and although he mentions law in his text, in his article, he didn't deal specifically with the problems of credibility and law, because of course it wasn't his area. However, this is not the approach, the take that I will pursue here this afternoon. What I will do is to use surveys on political trust to illustrate the point. So, as you know, there are many surveys on political trust. I'm going to use in this lecture 3 of them: the World Values Survey, the Latino or Latin Barometer Survey, and the Eurobarometer Survey. Any others? I think that the most reliable sources to understand trust and what people think about trust in interpersonal relationships and also in institutional terms are these 3 surveys. So, if we take, for example, the World Values Survey, what we have, and we ask people about the levels of trust in government and in parliament, well, the red line would denote mistrust, and the blue line would denote or represent trust. We see in the first case, trust in government, that after the wave of 1999, mistrust goes up, trust goes down, until we get to the current situation in which mistrust levels are skyrocketing. If we take a look at what happens as regards parliaments, we have an even more complicated picture, because trust in parliaments has been higher than mistrust only in the first wave of the World Values Survey. After that, mistrust has been going up until we get to the wave of 17-20, in which once again mistrust is skyrocketing, is going really high. Well, how about regional context? I cite the Latino Barometer because I did some research for the Carolinas Foundation in Spain, precisely on trust, in institutional trust in Latin America. But also because I think it's interesting in this framework to give more specific evidence of what is going on in this area in particular regional contexts. So, what does Latin Barometer says? As regards trust in government, the situation is horrible. Mistrust has been always the case, and in the last 5 to 10 years, 5 years, mistrust is skyrocketing. And as regards parliaments, the same situation holds. Okay, as we are in the Center for European Legal Studies, let's give a hint of what is going on in Europe. In Europe, the situation is not much better. What we have here in this graph, I hope you can see it, yes, is that people are asked about trust in the European Union, trust in national parliaments of the member states. and trust in the national government. So the blue line would be European Union, the red line, national parliament, and the gray line would be governments. So the only episode in which trust is higher than mistrust belongs to the European Union, and it's in between 2006 and 2007. And this is where the European Union gets a mark of 57, which means that there's more trust than mistrust. But for the rest of the time, what we have is that trust in the European Union is lower, 50%. And regarding the national parliaments and the national governments, the situation is even worse. We focus on 21-22. What we have is that only 36% of the people who trust national parliaments and only 35% of the people who trust member states' governments. So, the conclusion would be, Houston, we have a problem. I'm afraid to say that this problem has been aggravated in the last 15 years or so. And in particular, regional contexts like Latin America, this problem is particularly acute, particularly important and troubling. So, the question that Thomas Schelling did not tackle, and I would like to address, is how law takes hold of all this. What is the consequences or the reaction that, or the implications that all this evidence, I mean, surveys are worth for what they are worth, but this is what we have to try to understand what people think about institutional trust. So my point, my preoccupation here is what are the implications that all this has as regards law. So on the basis of this evidence and of this context of increasing mistrust in institutional, in particular institutions, key institutions like parliaments, governments, political actors, I would say, because I didn't show you the surveys on political actors and political parties, the situation is even worse. Well, I have started a reflection on what I have labeled law as credibility. So law as credibility is a theory of law that argues that the main function that law is called to perform is to give credibility to political commitments. So, therefore, political promises are encapsulated in law as a way to give them more credibility. So, let's give a particular example. This is a paper that I published in 2008 in the European Journal of Legal Studies of the European University Institute. And I deal with presidential term limits. So, as we all know, the 22nd Amendment of the US Constitution says no person shall be elected to the office of the president more than twice. You probably know the story of behind this amendment. Franklin Delano Roosevelt was elected, if I'm not wrong, 4 times to the office of president. And after his death, there was an agreement between the Republican Party and the Democratic Party on the need to establish limits to presidential terms. So they agreed on a constitutional amendment that took effect into the 22nd Amendment to the US Constitution. Since then, nobody has doubted in the has had doubts in the American context that presidents would step out after the second mandate. Compare this situation with the Spanish one. In Spain, in our constitution, we do not have presidential term limitation. However, as now in 96, promised as a way to clean the Spanish politics, that he would step out after his second re-election, his second mandate. In turn, Zapatero promised exactly the same thing once he got elected in 2004. And it is interesting to cite and remember what Zapatero said here, because he said, well, I think that this was interesting to establish a presidential term limit. In Spain, we do not have a presidential system, but the prime minister has become, with the years and with the costume, political costume, a kind of president. Well, he said, so Zapatero said that he would maintain Aznar's commitment. Well, the point is that when the second mandate of each of them was coming to an end, there was much debate about whether they would honor the commitments or not. And only after Aznar nominated a successor, all rumors, all talks about whether he would stand by his commitment or not ceased. And for Zapatero, interestingly enough, the same happened. So only when Zapatero appointed between inverted commas, Rubalcaba as his successor, all talks, all rumors, all discussions about his commitment ceased. So we see the difference. Okay. So law's credibility as a legal theory rests on 6 main propositions. So the first proposition is that all normative systems, and by normative systems, I understand systems based in rules, like morals, religion, politics, ethics. So law as credibility as a legal theory views all these systems based in norms as credibility devices, must be seen in terms of credibility. Okay? All of them must be seen in terms of credibility. So, and just to cite an example of what I mean by this, let's go back to the presidential term limits tradition. What we have is, on the one hand, a legal commitment in the US Constitution, a constitutional commitment, and on the other, a political commitment in the Spanish case. Both of them, the legal realm and the political realm, are seen in terms of credibility. So the second proposition would be, for law's credibility to work, law should be the normative system that renders more credibility to commitments compared to any other normative system, so that LC, law's credibility, is higher, or law in terms of credibility is higher than other normative system in terms of credibility. Okay? So if law is working properly as a credibility-given device, when political actors want to be the highest amount of credibility to a given commitment, they should choose law. If they don't, it is because the system is not working or for other strategic reasons, of course. Okay, so proposition 3 is that if 2 is the case, if position 2 holds, then law should be preferred to any normative commitment system to give credibility to commitments. Proposition 4 is that there is a main difference between law as a credibility device compared to any other normative system. This is that for law, rigidity always has to be superior, be it marginally, to flexibility. And this is denoted by the following formula, which is written here: LC, law's credibility, equals R, which is higher, to F, being R, rigidity, and F, flexibility. And this is an important point. This is a crucial point to understand in comparative terms the legal realm and other realms like ethics, morals, politics, or whatever, religion even. Because it's true only for law that rigidity is superior to flexibility. If rigidity is not superior to flexibility, we will not, that would be a sign that we are not in the legal realm. We would be in a different realm, be it politics, morals, etc. This is a very important point, above all for us lawyers. Fine. So proposition 5 is an internal condition. So for a particular norm to give credibility to a particular commitment, here we are speaking more about particular commitments and particular norms. So we are going down, we are descending to more specific aspects of the theory. Well, that particular norm has to be an equilibrium between R and F, between rigidity and flexibility in Nash terms. Therefore, and this is really crucial, it is not always the case that the most rigid norm is the most credible one. Instead, only norms that are an equilibrium yield credibility, so that we have this graph here. The red line is flexibility, or the orange line is flexibility, the blue line is rigidity, and that is the particular equilibrium point for a particular commitment, which is 6 for rigidity, 5 for flexibility. That would be the equilibrium point in Nash terms. I insist on this. Okay? Well, what do I mean by this? For example, let's take Lars Wink's beautiful article of 2020 on the Weimar's constitution. He gives a very good example to illustrate this point, which is that the Weimar constitution inserted, the Weimar regime inserted a constitutional tradition which was on the protection of civil servant rights to access their personal files. Okay? So Vinks very rightly discusses in his paper whether this was correct or not in legal theoretical terms and in constitutional terms. My favorite example here is the traffic road regulations, what we call the traffic road code in Spain. Of course, this is important because many people, thousands of people die, at least in Spain, and I guess that it's the same in other countries, out of traffic accidents. So instead, I mean, in itself, the traffic road regulations are important, but would we insert the traffic code regulations into our constitutions, into the Spanish, or well, Britain does not have a written constitution, but the German constitution, etc. Well, probably our intuitive answer is no. Would be too rigid, lost credibility would say. And the same discussion the discussion on eternity clauses is also connected to this proposition here. How about eternity clauses? The German constitution, as we know, and other constitutions have eternity clauses. So eternity clauses, as we know, are the most rigid of the most rigid, if we could call them like that, constitutional norms. Are they appropriate? There are certain constitutions, like for example, the Spanish constitution, that does not include eternity clauses. And there was a big discussion, what when the Spanish Constitution of '78 was discussed, about the need or the appropriateness of inserting alternative clauses in the new Spanish Constitution, in the democracy in the Spanish Constitution, and also because our Constitution was very much inspired by the German Constitution. And at the end of the day, the founding fathers decided that it would be too rigid a thing to do. And they excluded the possibility of inserting alternative clauses in the Constitution. So just to cite another example, the European Union Treaty does not have alternative clauses, does not include alternative clauses. There are certain provisions of the European Union Treaty and of the functioning treaty of the European Union that are very difficult to be amended, but they are not eternal. Okay. Proposition number 6, deposit an external condition. So therefore, for a legal system to yield credibility, two external conditions to the structure of the norm have to be respected. So the first condition is that people have to trust in courts, of course. And the second one is that the polity has to be vigilant as to the maintenance of the role of law as credibility. So one has to do with courts and the other has to do with democracy. Okay, so I would leave 2 for a different discussion because that would lead us really, really very far away. What I will just say about that is that I am very much influenced by an author that I consider one of my masters, my influencers, if we can use this term, who is Philippe Petit and his new republicanist thinking. So as we know, Philippe Petit argues that in order that the Republican theory holds, we need a virtuous polity, a virtuous society. And in my terms, that would mean a society that really, really is vigilant about democracy, the rule of law, etc., but also about, in particular, law as credibility. I know this is very contentious because law as credibility is just a legal theory. We know about it because we are academics, but people do not. Okay, I will leave it there, but of course that's a very big discussion. Let me focus on one. One is a reminder that people have to trust courts. So how about that? Well, there are in this kind of gloomy presentation, no? I mean, because the news are quite depressing. We believe in democracy, of course. But there are certain good news. We take the World Values Survey once again. What we see here is that people trust more in courts than in other political actors. So since the wave of 1884, people started trusting more courts than mistrusting them. There is a reversal in the 95-99 wave, but after that wave, things got better. And today what we have is slightly more trust in courts than mistrust. Of course, this is, pouring the cold water into the whole thing. If we take a look at particular regional contexts like Latin America, the situation is not the same. So it is important not to take for granted the outcomes of all these surveys. What we have in Latin America is also a very depressing situation in which mistrust in courts has been always higher than trust in courts. And the situation is getting even worse in the last 5 years. So, capture this image mentally. We go back to this. the situation, this is the Latino barometer once again. I mean, the situation is very similar as regards governments, parliaments, and courts, rather depressing. Okay, so I'm getting to the end of this presentation. What I will do is to frame some questions rather than try to answer them, because of course this is a legal theory in the making. The first question is, can law's credibility work with this level of trust in courts and in political actors? Well, probably the answer is a big no. We would need more trust in courts, not slightly more trust in courts than distrust. And of course, we would need more trust in political actors, in governments and parliaments. What I mean by this is that, of course, law is called to solve that problem from a law's credibility perspective, that trust problem in political actors. But the margin is so wide, the difference is so wide that really, I mean, it is very difficult for a theory like this one to work with this situation, with these tools. Second question is there a compensation effect between trust in courts and trust in political actors? Well, maybe the answer to this question is positive. My intuition, this is very intuitive. My intuition would be that higher levels in courts would spill over in trust levels in political actors, in governments and parliaments positively. So that we should, I expect at least that higher levels, but higher, I mean, not what we have now, levels in courts would have a positive effect in parliaments and governments. So we need to do much more as regards trust in courts. The third question would be, do politicians have a vision of themselves as the Baywatch of the law's credibility system? Well, probably not. And that is maybe an important part of the problem. Even more important, I would say, that trust levels in courts, etc. And well, we could discuss on this, for a long time, why this is the case, why it is the case that what we have is decreasing levels in political contestation in societies. Why is this happening? Of course, I'm not speaking about a purely contingent explanation. We had the 2008 crisis, the pandemic, and now a war. But I don't think that, of course, all these events do not impact positively on how the society behaves as regards the maintenance of the credibility of the law. But I think that the current is more profound, and it comes from the last 20, 25 years. And I would even say, even go a step farther, and I would say that it has very much to do with the neoliberal reforms that were undertaken after Thatcherism, etc. Not only in the UK, of course, but in the rest of the globe. Well, I'll leave it there. And the last question, is law seen in terms of credibility? Well, probably not. Maybe this is the problem. And I think when I ask this question to myself, I think in particular in judges. I've been discussing this issue with several judges in the Spanish Constitutional Court and also in the European Court of Justice. And they agree that although they cannot say it, they have credibility concerns in their minds when they are deciding on certain cases. So, for example, I have in mind the Whaler case, in which I really think that credibility and counterfactuals played a really very important role in what the court decided on that particular case. But they are the answer to my question is, well, yes, but how to make it operational in legal terms? How to make it operational in legal terms? And of course, that is a problem. And this is the area in which I am working right now. And I hope with results in the following years. So thank you very, very much for your attention. I think it's a little bit less than 40 minutes. And thank you for your attention. And of course, if there are any questions, I will be happy to answer to them. Thank you very much.
Okay, thank you very much. Now, thank you very much, Antonio. And this is an open invitation to all who are attending today online to ask questions using the Q&A button. But my first, if I'm allowed, the first question, Antonio, using my position as chair, and just to ask you, we're in the middle of a discussion on the future of Europe. And if you were to take just one change that you would make to the EU treaties to use the law as credibility framework and to increase trust levels in European institutions, which one would you take?
Well, that's a very, very, very good question that goes straight to the point of my concerns about credibility, law, and the European Union. And here the example is, of course, European economic governance. So give you a couple of examples. One example is article, if I'm not wrong, article 122 of the European Function Treaty, which says that bailouts are prohibited. This article rules out bailouts. Okay. However, and it does it in a very clear way. I mean, it's not just something that can be interpreted by different political and legal actors. No, I mean, it is very clear-cut, the treaty on this. Bailouts are prohibited. However, what happens in the 2008 crisis is that the European Union made up to 8 bailouts, and some of them were to members of the Eurozone, because it is more debatable if the European Union can or not bail out member states that do not belong to the Eurozone. That maybe it's more possible, but what is clear is that you cannot bail out the Eurozone member states. Spain is in the Eurozone. Spain was bailed out, just to cite an example. Okay? So, on the one hand, bailouts were perfectly reasonable at that time. You really had to make bailouts. You really had to operate bailouts. If not, the Eurozone would have collapsed. So please understand me right when I say this. When I'm saying this, I'm not saying that because it has been, I have been criticized for that, doesn't mean that bailouts, that I don't agree with the bailouts that were operated at the time. No, on the contrary, I think that bailouts were necessary, and probably more bailouts were necessary and more extensive. However, in terms of law's credibility, that poses a problem. That poses a problem. There is a problem. Because you have a very clear-cut, completely transparent, and you and me, Marcus, know that European law can become not very transparent sometimes, very blurred and very obscure. But here we have this classical provision that we all lawyers love, European Union lawyers love, transparent, clear, does not need much interpretation. And 8 bailouts were operated. So what would law's credibility would be your second question. You probably have it in mind. Advice, what to do? Well, either in mere terms of law's credibility. Well, either you do not operate bailouts, or you reform the treaties and eliminate that clause. I would stand for the second one, of course. So that's a particularly good example of what I mean. In terms of credibility, that wasn't very credible. We do not know now. Imagine that another heavy financial crisis explodes in 2 years' time. What are the markets the financial markets going to think about it? Probably that member states are going to be bailed out, but then how about the credibility of the whole system? And of course, the lack of credibility of one important constitutional provision spills over the rest of the system. That is the problem. So my advice would be just eliminate that provision. It's completely incredible. Okay, and of course we could cite many other examples. The second example, also from the area of European economic governance, would be the central bank. The central bank. We need to reform the statute of the central bank. It's a necessity. Why? Because we've seen it during 2008. We've seen it during the pandemic, and we will see it in the future. The European Central Bank has reinterpreted its own statute much beyond what the treaty says. The European Central Bank is not taking care anymore of inflation targets only. Okay, it has clearly expanded its mandate. If this is so, and it looks like it is accepted by, political actors, legal actors, and also financial markets, the European economic governance area is really very important, because we have this one actor, which is financial markets, which are undetermined, but are there, and play, confuses the whole thing. The whole game is more confused because of that. But financial markets have so far accepted that the European Central Banks should do more things and should come to the rescue of member states when they are in difficulties, in financial and fiscal difficulties. If this is so, why not put it in the treaties? That would be my advice. Those would be 2 examples. We could cite other examples. I have not worked in the area of Article 7 of the European Union Treaty, but that would be probably another example. Take a look, for example, at fiscal rules, the Stability and Growth Pact. There has been never, ever a sanction imposed upon a member state which has make infractions to those rules. Never, ever. Okay, so that's a couple of examples, but we could, of course, discuss much more on this and could give you many more examples on this.
So we don't have any questions online. Nora, do you have a question?
I just didn't quite understand I think it was proposal 3 and 4, where you first said that law has to be more rigid and flexible, but which I understand, but then you said in the next proposal that we need this equilibrium.
So it's a proposition 3 and 4?
Yeah.
Okay, so proposition.
Seems like contradictory to me.
Okay. So proposition 2, let's start by proposition 2, because the 3 is like a sub proposition that comes from number 2. Last related work, law should be the normative system that renders more credibility to commitments compared to any other normative system. Okay? So if 2 is the case, then law should be chosen. Okay? So it's a little bit tricky. I mean, if you compare all the different normative systems that we have, politics, ethics, religion, customs, and law, law should be the normative system that renders more credibility to commitments. That's first. But second, it's the third proposition is thinking about choice that political actors would make. Okay, so this proposition number 2 is a general state of affairs, and if proposition 2 is the case, then we go to the choice that political actors would make. That choice, if they are rational, should be to choose law instead of politics, for example, if what they want is to render the highest degree of credibility to that particular country. For strategic reasons, they might not want to do that. Like, for example, in the Spanish case, when I use the example of presidential term limits, I'm not saying that the Spanish constitution is not credible. What I'm saying is that both Aznar and Zapatero did not want really to tie their hands. They wanted to have more flexibility than rigidity. That is the point. In that particular case, if they would have wanted to have more rigidity than flexibility, and my theory holds, they would have chosen a constitutional amendment, as happened in the US.
Yeah, but I just wonder if law, in my opinion, law is also or can be to a great extent flexible. For example, if you interpret it differently or you have just general statements. So
this is what I try to represent here. I mean, the question is very good and really got to the point of the whole theory. This is what I try to represent here. So why do I say this? For economists, law is equated with rigidity. Maybe you are an economist.
no, I'm a lawyer.
Okay. So law amounts to rigidity. So the only, the very few times that in which they mention law when they are speaking about credibility in economics, for example, central banks, etc., inflation targets, etc., is because law amounts to rigidity. Okay, that's maybe right in economic terms, but not in legal terms. Legal terms, the situation is more complex, precisely for what you said, because sometimes we need to have very high degrees of flexibility even within the law, the legal realm. You're right. I mean, sometimes norms are quite flexible, not only in terms of the normative system, but also in terms of how they are framed. Okay, fine, that is fine, perfectly fine. And this picture represents that. However, one condition has to be sustained, which is that rigidity has to be higher than flexibility in the law realm. Because if not, we are in a different realm. We would be in a different normative system. And this is the important, sorry, let me see where it is. Yeah, this is. Let me see, yeah, less credibility, sorry. Less credibility equals rigidity higher than flexibility. That has to be true all the time. If it weren't true, we would be in politics and religion. We have, therefore, different combinations of rigidity and flexibility. And we could, of course, discuss the combinations that we have in politics, in ethics, in religion. But my point is that, fine, that's fair enough. But the difference between law and the other worlds is this one. Only in law, it is the case that rigidity is higher than flexibility. And I said in the, I think it's written here, be it marginally. Sometimes the difference between rigidity and flexibility in the legal realm is just a question of, nuance and qualification. But it has to be higher than flexibility. And I agree with you. I mean, we have very flexible norms and that are framed in a very flexible way. And of course, this is why we have a different normative system, a pyramid. Because we do not want to have the same degree of rigidity all the time. If not, this is what I explained to economists, if not, we would only have constitutions and not law, regulations, etc., etc., etc. So the normative pyramid, even in Keynesian terms, the normative pyramid represents a different relationship between rigidity and flexibility. The highest degree of rigidity and the lowest degree of flexibility would be up in the constitution. The lowest degree of rigidity and highest degree of flexibility would be in regulations. Okay, so I try to capture that problem that you mentioned in this formula here. Basically, that there and here. Of course, you will have different situations all the time. The point is to find the right equilibrium for a particular commitment. That is the point. So, in theory, at least, when we find very unstable norms, this is because they do not represent an equilibrium. I give you an example. In European Union law, for example, the Stability and Growth Pact. We have reformed the Stability and Growth Pact 1,000 times, 1,000 times. Okay, that's a signal that the system is not an equilibrium. That legal system, that particular complex of norms, is not an equilibrium. Okay, if on the other hand you have a norm that has not been, for example, just to cite another provision from the treatise, European Union treatise. I don't know, I think it's Article 2, I speak by heart, Article 292 maybe, or 96. The provision that defines what directives, regulations, and decisions is. That has been inserted in the 57 European Economic Community Treaty. Since then, has not been reformed. Why? Because there are no incentives at play there. It is an equilibrium. It works. In credibility terms, okay, there have been, of course, proposals to reform that and introduce European laws, European organic laws, and all that. Yes, that's another matter. I mean, that provision is self-sustained. Thank you.
Antonio, I'm afraid that is all we have time for.